mejor es que te pongas a pensar en las cosas buenas.
City of Tampa Variance Review Board. From my left, the members of the board are
Sam Walker.
Susan Long.
Dustin Pastor.
Brett Feldman.
Lynn Hurtak.
Also in attendance this evening are from legal, Ms. Kamaria Pettis-Mackel, from Development Coordination, Mr. Eric Cotton and Brett Burks, and from Natural Resources, I think we have somebody filling in, which we can introduce when she speaks. There's some procedural rules you need to follow. Due to COVID-19 pandemic, please adhere to safe social distancing as set within the room, and please maintain wearing your mask at all times. When your case number and petitioner's name is called, please approach the podium. When you approach the podium, please state your name, address, and if you have been sworn in. The petitioner and/or their agent will have 10 minutes to make a presentation. Please make sure to clearly state your hardship criteria as submitted in your application. All other participants wishing to speak will have 3 minutes, and then the petitioner will have an additional 3 minutes for rebuttal if needed. The time periods as stated will be kept by the board. Any information such as pictures or plans that have not been previously submitted as part of your petition that you intend to present at this hearing for consideration in support of your petition must be individually presented and accepted by the board. After acceptance by the board, you must submit the item to staff for it to be entered and made part of the permanent record. The board bases its decisions on competent and substantial evidence which is presented and which meets the criteria required by the city's code of ordinances. The variance granted by the board will be only for what is shown on the site plan and will be in compliance with any terms and conditions stated in the approval by the board. All other city codes will need to be met. If the case is approved, your variance will expire 2 years from the date of the decision. If the case is continued, it will be continued to either next month's VRB board agenda or the next available position on an upcoming agenda. If the case is denied, you may wish to have the variance board's decision reviewed or appealed by city council. You must file a petition for review by the board's decision within 10 business days of the written decision. You will not be able to pull any permits until after the 10-day review period has passed. Your cooperation ensuring that this meeting is run smoothly is greatly appreciated. May I move to approve the minutes without objection?
Brett Feldman, motion to approve the minutes.
Is there a second?
Lynn Hurtak, second.
Thank you. And a vote, please.
Sam Walker, aye.
Susan Long, aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Lynn Hurtak, aye.
Thank you. At this time, I'll ask legal staff to confirm any ex parte communications and conflicts.
Good evening, Commissioners. Will any of the Commissioners state for the record, Kamaria Pettis-Malcolm for the record, Assistant City Attorney. Will the Commissioners please state on the record whether or not they have had any ex parte communications regarding any of the items that are listed on the agenda?
Do you want to do that individually?
Well, has anyone had any ex parte communications with, okay.
No.
Seeing no responses from all the Commissioners for the record. Additionally, will the Commissioners please state whether or not there are any conflicts of interest regarding any of the items that are listed on the agenda?
Sam Decker, for reasons that have already been disclosed to the legal department, I am going to recuse myself from case VRB 20-64.
And just for the record, will you, Madam Commissioner, provide the Form 8B disclosure at the end of the meeting?
Yep, I will
Thank
do
you.
that.
Okay. With that being said, is there any business regarding the agenda that staff would like to address?
Yes, sir. Eric Cotton, Development Coordination. VRB 2055 for 3509 West Empedrado and VRB 2056 for 714 West Indiana. Both misnoticed. They're being moved to the December 8th public hearing. And if I could get a motion to move VRB 20-64 forward on the agenda. The normal person that would be here, Owen from Natural Resources, and his backup are both unavailable. So Mary Danielowitz Bryson is here, so she can get, since it's unexpected for her, so she can get on her way.
Okay. We've got a motion to move VRB 2064 to the front of the agenda due to city staffing issues.
Brett Feldman, I'll move to move VRB 20-64 to the front of the agenda to accommodate city staff.
Lynn Hurtak, second.
Thank you. And a vote, please.
Sam Walker, aye.
Susan Long, aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Lynn Hurtak, aye.
Okay, thank you. Is there any new business that staff would like to address?
No, sir.
Thank you. At this time, I'd like to ask staff to please conduct a swear-in.
Please stand and raise your right hand. Do you swear to or affirm that the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth?
Okay. So then the first item for this evening is VRB 2064, located at 1110 West Union Street. Is the applicant present? Yes? Okay. Staff report, please, Mr. Cotton.
Thank you, Mr. Chair. This is, again, as you stated, VRB 20-64 for a property at 110 West Union Street. The zoning is NMU 35, which is neighborhood mixed use. The property owner is the Housing Authority of the City of Tampa. The applicant is RUDG1 LLC, and they're represented by Stearns Weaver, David Smith, and Jacob Kremer. The applicant is seeking permission to remove 2 grand trees. Under 27-284.2.5, grand tree removal requires city council approval. and this is for the construction of a multifamily housing unit. Natural Resources found the request consistent with mitigation at the required, at time of permitting, and it did not trigger a transportation review. This criteria is reasonable use, more so than the hardship criteria. So the usual request that you will hear will be a little bit different. This is going to be reviewed under 27-284.2.5, subsection F, subsection 4. It's in the staff report, the criteria that you'll be reviewing. Just to give you a general idea where this is at, this is on Main Street, in the corner of Main Street and Willow. Willow actually dead ends into the property. You can see the site here. And it is a vacant piece of property, pretty well treed. The applicant has submitted different plans, which they'll go over for the different options they're trying to do to meet the requirements of the code. They are preserving a large number of trees, but in an effort to preserve most of the trees on the site, they are asking to remove 2 grands. And I'll turn it over to the applicant.
All right, applicant, please state your name, address, and whether or not you've been sworn.
My name is David Smith, 401 East Jackson Street, 33602, Suite 2100, with the law firm of Stearns & Miller. I have been sworn.
Okay, you've got 10 minutes to present your case.
Thank you very much. Staff did a very good job of providing an intro. If I might use the Elmo. The subject property is located, as indicated, in what used to be North Boulevard Homes. This was a public housing development developed in the 40s. It's been there until recently demolished for redevelopment into a mixed income affordable housing community as part of the West River redevelopment plan. Some of the members may have been present when we came in for Block T3 for similar variances. There are approximately 50 trees on this site, including right-of-way trees, and of those, about 64% exceed 21 inches in diameter. There are 6 grand trees on site, and the purpose of the overall NMU development for this part of Tampa is to create at 35 units per acre or 1.5 FAR development, mid-rise mixed-use development. The subject property is being proposed for 2 buildings and a common parking garage to accommodate 227 multifamily units with 7,000 square feet of retail in the bottom floor between the 2 buildings. What we've done during this process is we've looked at the reasonable use criteria and went through a number of iterations to see how we can develop this site, given the fact of the number of trees on site and the nature of the trees on site. And I'll go through those very quickly for you. Those are also in your packet. One of the options that was looked at in this particular development, and I'll go over some site constraints. The blue lines running through the middle of the site is a City of Tampa stormwater easement that runs to a retention pond that is due north of this subject property. This site was subject to not just this site, but a large part of West River was part of a contamination plume not caused by the applicant, but that has creeped over time into the site. Therefore, any retention had to be accommodated not on the properties, but on adjacent properties. And the only way to get the stormwater collected and put into a place where you could actually put a pond was to go through the center of this site. So this is a constraint that's come into play. Also, we've identified all the, in red, are the grand trees. These 2 trees were previously approved to be retained as part of the stormwater pipe location associated with T3, which I referenced earlier. So as you can see, we have a building, another building here, and the NMU is kind of unusual because it has build-to lines, and you have to be within those build-to lines. So it's either like 10 feet to 15 feet. And in order to do that, these trees would have been impacted by meeting those build-to lines. There's also the parking requirements. The parking requirements are such that we have to go to structured parking to accommodate these developments. And in looking at the placement of the parking structures, we have impacted 3 grand trees on the site as well. In looking at this further, we went through and dealt with the location of the buildings as well as trying to skinny up the parking garage and change the footprint of the parking garage. And the result of that was we still had, with the building itself, we still had impacts to 2 grand trees and these 2 grand trees, but we're able to save this grand tree. Lastly, in looking at an alternative, we were able to, in conjunction with filing this application, we filed design exceptions with the City of Tampa to get a parking reduction, to allow us to go to a taller parking garage, which would allow it to be narrower with fewer spaces, and also to expand the Bill 2 line so we could set the building back further from the right-of-way line. And that allowed us to save 2 grand trees in the front of the building, save this grand tree next to the garage, which is one of the best trees on the site, and only impact these 2 trees. We were very limited on where we can move the buildings because of the stormwater easement and the necessity to put utilities on the site in proximity to those existing easements. So we believe that, we have taken great steps to address the reasonable use criteria with respect to our design alternatives investigated. Going to a taller garage is not necessarily a cheaper garage. Trying to realign the site, get other waivers and exceptions under the alternative design criteria allowed by the city to save as many trees on this site as possible. The whole goal of West River is to try to save the tree canopies specifically along the roadway corridors and try to save as many specimen trees that we can, but still fulfill the goal of the city, which is this is one of their targeted areas for affordable housing. So we believe that looking at the criteria, that we have saved the best trees, we've limited the impact to the least necessary in order to have reasonable use of the property, that the alternative designs were thoughtfully developed and were not really looked at as the cheapest way to do it, but necessarily the best way to do it to save the best trees. And we have actually pursued other variances that would allow us to accomplish this minimum impact. We have the architect here, at least I think he is. We moved up on the agenda, so maybe he's here. We have the architect here. We have the developer here. We also have the arborist here if there are any specific technical questions. But we believe this is a reasonable variance to allow reasonable use of the property and fulfill the goal of West River and the goals of the city and vision for this area. Be glad to answer any questions and reserve any time.
Okay. Does that conclude your presentation?
Yes, we just have answers any questions from the experts if you have them, or questions that I can answer.
Okay. Does anybody in the audience wish to speak on this case? Seeing none, then we will open it up for board questions. All right.
I'm sorry, I just have one.
Go ahead.
Can you put the map back up of the trees with your final design?
Yes, sir.
I apologize if you said this. I'm just trying to understand. The second tree that's outside of the building envelope, that's the one. Yeah. The red line that runs through that, what's the reason that tree has to come down?
Well, the protective radius of the tree, the root structure in the tree is such that it's
Just too close.
It's just too close to the garage. It's also very close to the utility easement that runs through there. There'll be other utilities running through there as well.
Excuse me, can you use the
I'm sorry.
microphone?
I'm sorry, apologize for that. There's utility easements, this utility easement here is one, but we'll also have other utilities running through here.
Okay.
It's too close to the garage. The canopy and the protective radius are impacted by the construction that will occur there. And we just don't, the arborist, I think, can speak to why we believe we can't save that tree. I can tell you that the trees that we are saving are probably, they are the best trees on the site.
No, I understand that, and I don't need the arborist to speak about it. I just wanted to understand, it's outside the radius, but I do see the utility easements running through there. Thank you.
Yes, sir.
Okay. Then, without objection, we'll close the public hearing. I appreciate the clear explanation of all the hardships. That's helpful for us. Is there anybody that would like to make a motion?
Without any other objection, Brett Feldman, I'll make the motion. I would move that, sorry. I would move the variance request for case VRB 20-64 for property located at 1110 West Union Street be granted as depicted on the site plan presented at the public hearing for removal of 2 grand trees pursuant to section 27-284.2.5. Based upon the petitioner meeting the burden of proof with regard to the 6 factors for determining tree removal as set forth in that section, subsection F4 of the city code, for granting tree removal, specifically that the evidence provided in the record showed that the developer has utilized alternative designs to attempt to save multiple trees, that the developer has pursued other variances to avoid removing additional trees, and that the trees that are being removed are simply too close to the required build space or utility easements or other drainage type easements on the site.
Is there a second to the motion?
Lynn Hurtak, second.
Thank you. Let's take a vote. Ms. Long?
Aye.
Susan Long, aye. Dustin Pastor, aye.
Brett Feldman, aye.
Lynn Hurtak, aye.
Thank you. Your motion's approved 4-0.
That was short and sweet.
Okay. Next case is VRB 19108, located at 3305 West Abdella Street. Is the applicant present? Yes. Okay. Staff report, Mr. Cotton.
Yes, sir. VRB 19108 for 3305 West Abdella Street, property zoned RS50. I apologize for mispronouncing your name. Nelis Montano is the property owner. The agent is Frank Otero. The applicant seeking relief from section 27156 in order to reduce the front, to reduce the front yard, the rear yard, from 20 feet down to 10 feet for the principal structure and from 7 feet to 3 feet for the above-ground pool per 27290.3. These are existing conditions. There was an addition put on without permits. The board heard this case back in December of 2019 and denied the request. It was then appealed to City Council on March 19th, 2020. The City Council remanded it back to the board. And right now the VRB, as you can tell, the applicant's back before the board now. Just the aerial photo. Property is on Abdella, just west of North Lincoln Avenue. The site plan is highlighted in yellow. This is the pool. This is above-ground pools have to be principal structure setbacks. It's only at 3 feet versus the required 7 feet. And the rear yard needs to be 20 feet. It's at 10 feet. If the board has any questions, I'll be more than happy to try to answer them for you.
Okay. Applicant, please state your name, address, and whether or not you've been sworn.
Francisco Otero Castillo, 13014 North Del Mabry, Tampa, Florida, 33614. I have been sworn.
Okay. Got
I
10
was-
minutes to present.
I wasn't part of the first hearing. The applicant is here. She's the owner of the property. And during the first hearing, I guess there was an issue with her interpreter, and she doesn't speak English that well. So then I came on board. So I'm here actually as the applicant, and you could ask her questions too. Now, to clarify our request, I have a picture. This is the rear of the structure. As you can see, we're requesting a 10-foot setback, so there still is 10 feet to the rear of the property. So we feel that the request is pretty basic, that it's not right up on the property. And the other request for the pool, she decided just to remove the pool completely, so the pool doesn't exist. So we would not need the second variance for the pool. And then concerning the hardship, the original hardship that she presented to the board the first time around, the structure was built as a kind of like an in-law suite for her son. He, at the time, was involved in a motorcycle accident, and he was going to be living there with her, but he since has passed away because of the motorcycle accident. And the original hardship was that facility was going to be for her son. Now, she's a single mother, and her mother doesn't live with her, but she does come in from time to time from New Jersey to stay with her daughter and to keep her company since her son passed away. She basically decided to remove the pool, but she basically wishes to keep that structure because she's in much need of it. And I'm here to answer any questions, and she could answer questions too.
Could you maybe be a little more clear on what exactly the ask is, what the situation is? I know, like it was 11 months ago that we heard this, so we don't remember that. I know you just showed a picture, but.
Yeah, like I said, I wasn't part of the original.
But for this one?
Yes. Basically this is actually the rear of the structure. And here's the setback. I guess the addition is kind of a mini apartment. Inside is a bedroom, and there's a kitchen, but with no oven. So it's just a room, a small nook for a kitchen, and a bathroom.
You have a site plan or anything?
Yes, I believe originally on the original presentation there was site, but I don't have a site plan with me. But it basically is the request is 10 feet. Well, I think, oh, there it is, I'm sorry. There it is. So here's the back of the addition, so the request is for the 10 feet. And the pool was here, but she removed the pool, so it's just the rear setback for the addition. And she understands too that it was built illegally, so if the variance is approved, she would still need to go through permitting and submit engineering and get that permitted. And the work that was done already, if it wasn't to code, it would be removed and built properly to code.
Okay, does that conclude your presentation?
Yes.
Okay. Is there anybody in the audience that wishes to speak on this case? Seeing none, we will open it for board questions.
So you're not asking for the side yard setback, only the rear yard setback from
Yes.
20 to 10?
Yes, because the pool was the issue for the side, but she removed that completely.
Okay, so the pool's gone.
Yep.
Side yard setback, not part
It's
of
in
the
compliance.
action. Got you.
Yes.
Thank you for that clarification. Can you, just succinctly for me, can you restate the basis of the hardship for the reduction from 20 to 10, just so that I have it and understand it for the record?
Yes, originally she obviously built the structure without a permit. And then considering the lot size of her house is small, to be able to fit an adequate size, addition to the back, she basically just needed the additional 10 feet to fit, a nice sized bedroom with the bathroom. So the hardship, I mean, she basically built it illegally, but, you know, the hardship, if she would have came get the variance first, you know, the hardship would have been, you know, get the variance first, get that approved, then be built, and the hardship would have been that the size of the lot is just small for her family.
Okay, so perfectly understandable. We very often address these types of situations by looking at what we would do if somebody's coming in to make that request.
Right.
The request, you're saying it's a small lot. How many square feet are in the house? Before the addition, how many square feet are in the home?
¿Tú sabes cuántos pies cuadrados tiene tu casa?
No, pero
No.
yo tengo un cuarto para mí, uno para la niña y uno para los juguetes de la niña. Y
¿Cuántos cuartos tiene?
3, pero uno muy chiquito.
Yeah, she doesn't know the square footage, but from my estimate, it's looking around, is it 2,500 square feet?
That protruding structure, looking at the site plan that you had, the protruding structure in the back, was that whole thing the addition, or is it just the yellow part that was the
Oh,
addition?
it's the whole thing,
The whole thing was
Yes.
the addition?
yes.
Okay, so the original home was 34 and a half by
Hold on.
30,
Excuse me, Kamaria Pettis-Mackel from the city attorney's office. You're pointing on that screen,
Oh, I'm sorry.
and no one can see you
Okay.
pointing on that screen.
you got to go to
Hold
that.
on one second.
Yeah.
Thanks. Yeah, so the original house would be.
Microphone?
Yeah, the original house would be this line right here. So this would be the addition.
Okay. So not a very large house
Yes.
on not a very large lot.
Yes, sir.
So it looks like the lot's 85 wide by 103 deep. Is that correct?
Yes,
So that's a larger than average lot
right.
in the city of Tampa, I believe.
Yeah, the lot's big, but compared to the structure was small.
And Kamaria Pettis-Mackel from the legal department, staff can certainly answer that question about the lot size.
Yeah, Mr. Cotton, could you tell us your opinion on the size of that lot compared to a typical Tampa residential lot?
Well, the zoning is RS50, so the minimum lot size for the district is 50 feet wide and normally 5,000 square feet, so typically a 50 by 100 foot wide lot.
Right, okay,
A little bigger.
that's what I thought.
Yeah, the lot's definitely big for the area, but the house is the same size as most houses there.
Right, but that's what I don't understand. If the lot's big and the house is about normal, then what is the hardship? I don't understand how the lot is creating a hardship on this situation.
Well, if you look at the big picture here, we're kind of working backwards.
Yeah.
It's just, obviously, she built it before the permitting and the variance.
I understand.
So, you know, a better solution would have been, instead of building toward the rear, to build toward the side.
Yeah, potentially.
Yeah, there's a few other options we could have done, obviously, yes.
Right, so regardless of it was built or not built, if we're looking at the hardship on this property, that's what we need to have documented in this case. So what is the hardship you are claiming, regardless of the fact that it's existing?
Well, the hardship that we were claiming is considering the circumstances of the additional square footage needed is, yes, I mean, I understand what your point is,
Okay.
but I guess the hardship would be, in this situation, having to remove the actual structure that's already built.
Okay.
The challenge that we face, sir, is that we cannot consider that it's already been built. That's just,
Right.
we're just not able to do that and look backwards like that. We certainly can look at it in this imaginary scenario of, let's pretend it wasn't built, let's start from scratch. But what we need is to understand why this structure needs to be there and why it needs to be there, where it's placed, so that it cuts into the into the setback. Why is there some reason that it needs to intrude into the ordinary setback based upon where the structures exist, not where they have been built illegally, but where
Right.
legally built structures exist, and why they can't go somewhere else on the lot. Let me ask it a different way, and maybe this will help you understand. Inside the original structure, as it was currently built, can you give us a little bit of a breakdown of how things are set up so that we can understand why you wouldn't build off the side, perhaps because there's a bedroom there or something along those lines, and why it would need to go backwards instead of sideways?
Yeah, when you walk into the front of the house, there's a living area, and then all the bedrooms are to the right of the structure, and then the kitchen is in the back. So it's pretty, a pretty standard, floor plan. But I see that the point is if she would have came to me directly first before this, we would have oriented the structure to the side of the house. So I understand that.
Well, is there a reason, what I'm asking you is there a reason why, as things are built, I mean, does it make sense? Is there a connection between the kitchen and the continuing structure? Does it make sense to place?
¿Por qué fue la razón que tú fabricaste la horizontal atrás de la casa y no del lado?
Porque tenía más espacio atrás, no sabía tanto de código y mi hijo quería un espacio para vivir conmigo y no separarse de mí nunca.
Yeah, she basically says that her best option was the rear of the property, and then her not knowing the code at all. She had no idea about codes, building codes, or setbacks, and then it was her and her son's decision to build the structure to the back of the house for privacy for him.
Do you have any other
No,
questions?
go ahead.
Lynn Hertek, I've got a couple of questions for you. The first one is this addition at all attached to the house?
Yes, it is.
Meaning, is there a door between them?
Yes, there's a door. But
Okay.
Yeah, there's a door. She installed a door from the door is basically in the back of this kitchen. There's a door into the back of the house. So it's,
Okay.
it's considered one house now. It's not detached at all.
Okay, well,
It's a part of the house.
Okay, excellent. That's my first question. My second question is, in the packet that we received, it does talk about one of the reasons, which wasn't mentioned or hasn't been mentioned much, and it talked about the son's accident, and they had to put metal in his clavicle and his arms. I did it for him because he could not climb the stairs. Are there stairs to this house?
Yes, there's stairs
tiene escaleras.
in the back of the house, and it's kind of they extend down toward the back of the house. So yes, there is. To answer your question, there is.
So there
And
was
And the
no
orientation
way.
of the stairs, that's the perfect, the side, straight back on the sides instead of, horizontal, so.
So my question is, was there a way to enter the original house not using stairs?
Yes,
There was?
yes.
Already? Okay, okay.
Yeah, from my understanding, there is, yes.
No, not saying now,
Yeah.
before it was
Oh,
built?
yes.
Okay.
Yeah.
Any more board questions?
I have a quick question to follow up on Ms. Hertek's question. So the picture that we have, it looks like to get into the front door, there are a couple steps. So I just want to clarify that her question was whether or not, could you walk from the street level straight into the house, or did you have to walk up steps to get into the house?
You could actually,
¿Qué dice?
You ask her.
tú puedes entrar de la casa por el lado de la casa. Can you repeat the question? I'm sorry, so I could translate to her better.
Yeah, so the picture that we have of the front of the house, it
Okay.
shows that there are like 2 or 3 steps to get up
Oh,
to
that's to the front,
door.
yes, okay,
Sí.
yes.
And so is there a way to go straight from the street level into the house without walking up steps?
¿Cuál es la pregunta?
No,
Okay.
no.
Ms.
So that's
Hertek,
why,
does that
that's
get
where
to
her
your
question came in for the steps in the rear of the house, for the,
Okay, so the build of the house was such that in order to get in, you had to walk up steps?
Yes,
Okay.
yes, from both sides. From the front side, and there's the steps on the side, but they're both steps going up,
Okay.
yes.
Lynn Hertek, so I think that was what I thought when I was looking at the site plan. And so the question was, in this written statement, it says that the son could not climb stairs, and that was part of the reasoning for building
Yes,
it?
and I apologize for that, because I wasn't part of the original hearing, and then obviously when his son passing away, you know, obviously, well, now I understand the hardship was because of that, but since now that my understanding, from my thought process with him passing away, will that hardship still be in place? You know, since he's no longer, but that was the reason why it was built like that.
Okay,
Yes.
thank you, that
So
answers my
so the
question.
original hardship was that, yes.
And Kamaria Pettisnapple from the legal department, I think what the agent is just representing is that the reason, the original hardship request, no, that is different from what he's presenting for today.
No, she's just been through a lot, and like I said, she's a single mother now, and the back of the addition could be used for her in-law. And we just feel that, you know, there still is additional 10 feet of setback. So we just feel the request is.
So, question for legal, Ms. Pettis-Mackle. Is there a basis to rely upon a hardship that existed at the time that the original application came before us? Or must we only rely upon hardships that exist today?
Kamaria Pettisnapple from the legal department, the agent is representing what's going on, what the hardship is today. He's already stated on the record the original request, and I apologize for her loss. The original request is not, the original request is not, that's not the purpose anymore for the hardship criteria. It's what the agent is representing for tonight. The request, as the agent has represented, is to have that space for the in-laws to come and visit.
Okay.
Are there any other board questions? Seeing none, you have 3 minutes for rebuttal if you need it.
Yes, and thank you for that input. And you know, from an honest standpoint, you know, obviously since her son did pass away, you know, I didn't, you know, feel comfortable coming up here and, you know, requesting the hardship, because that hardship, you know, died with her son. But I appreciate you helping out the situation, and thank you. We have no further.
Okay, thank you. Then without objection, we'll close the public hearing and open it up for motion or board discussion.
Would anybody like to make a motion or discuss the issue?
So let's start the discussion this way.
Sure.
I acknowledge that it sounds like the way that the home is situated and the existing structures suggest a structure expanding in the rear makes some sense, and that there may be some practical difficulty as a consequence of that. The problem remains that though we've listened very astutely and tried to identify a hardship that requires moving into the 20-foot setback, I don't see anything that we can legally rely upon to do so.
I concur.
and I'm open to others who may see that otherwise. If someone has any suggestions that would see a hardship or practical difficulty allowing us to move into the 20-foot setback, I'm open to hear it.
I agree with Mr. Feldman. And I think that this is a particularly difficult case for.
Excuse me, could you speak into your mic?
Yeah.
I can't hear you.
I agree with Mr. Feldman,
That's
and I think that this is a particularly difficult case for everyone here on the board. I think my initial thought, and I assume that this is what Ms. Hertek was getting at too, is that if the rear construction was an accessory structure, then there would have had to have been steps going down the house to the accessory structure and then back up, which could pose a hardship such that we could potentially approve this application. In light of the fact that that hardship no longer exists, I wonder if the applicant could present evidence that her parents may experience a similar hardship moving about the house. And depending on, I'm very interested in what the rest of the board has to say about this, but if perhaps we could ask that more information be gathered and this case be continued. But if the board does not think that more, if the rest of the board doesn't think that more evidence would change the circumstances here, then, I agree that I am having a hard time finding a legal basis to approve this application right now.
To touch upon that, certainly we could open it back up for additional discussion on that issue. The dilemma continues to be, and will need to be answered if we do open it back up. Why, yes, access and ADA becomes a hardship issue that can be addressed, but to understand why it needs to go into the setback would be a key question to answer as it relates to that issue. So if a hardship relating to ADA existed, and we could open it back up and ask that question, or address it if additional time is needed to seek that information, we would need to understand that in order to grant what's being requested.
That would open up the question of size of addition, location of addition,
Sure. They would all have to be
why the
connected.
rear, why that size. Seems like a difficult case to make, but,
Well, would anyone like to, do you think collectively, let me do it this way. Let's move to reopen for public discussion to allow the applicant to at least address those questions. Is there a second for that?
Second.
I second that.
okay. Reopen the public hearing. for-
Thank you.
For
And,
board questions.
Answer our questions.
May I?
All right, so you heard our discussion. Do you feel that you can address that tonight? Or is it something that you would need additional time to investigate?
I would definitely like a continuance for 30 days, and my staff will definitely present the new hardship for the ADA, and I would definitely be prepared to document the hardship with photographs and updated site plans. So I respectfully ask for the 30-day continuance to make that case, and that'll be beneficial to my client.
And a quick follow-up, could you also please address why that particular location and size if we do grant the continuance?
Yes,
Okay.
yes, absolutely.
Mr. Cotton, how's the agenda looking for next month?
My understanding, Eric Cotton, Development Coordination, my understanding is the December hearing is full,
Okay,
as is, I believe, January,
okay.
although it'd be up to the board if they wanted to add one more case.
Well, Kamaria Pettis-Mackel from the City Attorney's Office. If both agendas are full per the rules of procedure. I would ask that it move to the next available agenda.
I was going to suggest the same. How would you feel about a February hearing?
That'll work fine. Give us enough time to prepare the case.
Okay. Would somebody like to make a motion for continuance?
What is the specific date, Mr. Cotton, for February? Actually, I think
I have to look at a calendar.
Looks like the
It will be
9th.
February 9th.
so if the motion could be
somebody made
for
a
a specific
motion?
date.
Okay.
I can make a motion.
February of what?
All right. Ms. Walker?
I move that variance request for case VRB 19-108 located at 3305 West Abdullah Street for a reduction in the rear yard setback from 20 feet to 10 feet with an encroachment of, for eaves and gutters, be continued to the February 9th, 2021 public hearing at 6:30 PM.
I'll second that.
Okay, we have a second. And could we take a vote, please?
Sam Walker, aye.
Aye. Susan Wong.
Dustin Pastor, aye.
Brett Feldman, aye.
Lynn Hurtak, aye.
Okay, been continued to February 9th.
Thank you. Have a good night. Thanks.
Hard to believe we're already into 2021. Not ready for that.
Yeah. The next case is case VRB 2048 at 2808 West Foster Avenue. I see Mr. Michelini is present. Mr. Cotton, the staff report, please.
Eric Cotton, Development Coordination. This is for VRB 20-48 for a property at 2808 West Foster Avenue. The property is zoned RS60. The property owner is Russell Olinger, represented by Stephen Michelini. The applicant is seeking to reduce the required building separation that's required under 27-290 from 5 feet to 2 feet 9 inches. That measurement is measured between the principal structure and the accessory structure, eave to eave. And that's because he's adding an addition to the principal structure. The DRC did not trigger any reviews. This case was heard by the board last month and continued at the request of the applicant. Just an aerial photo of the property. This is the front view. It's an existing two-story house. They're doing the addition for the site plan in the rear. This is the addition that's being proposed. I chose the cross-hatching. This is the existing accessory structure. So the distance separation is measured eave to eave at this location, from there to there. The board have any questions for me? Okay, thank you.
Okay,
Good
please
evening.
state your name, address, and whether or not you've been sworn.
Steve Michelini, I have been sworn, 2407 Sunset Drive.
All right, you've got 10 minutes to present your case.
I think that when the applicant first came before you, he was confused about how to explain to you what the differential between the two eaves with the existing accessory structure and the existing single-family structure. I'm going to show you an aerial photograph. It might help. You see where the red pin dot is? That's the proposed location of the addition, and then it would extend out along the edge of where you see the accessory structure here. But the height differential between the eaves is a little over 19 feet. So that the separation at the ground level is the building separation, which is 5.5 feet, and that meets the code. That when you apply the eave-to-eave separation, it doesn't meet the code. And the only practical way of doing that is to seek a variance between the eave-to-eave separation, although there's a height differential. The only other way he could meet that would be to change the roof line of either the existing main structure or the existing accessory structure, either of which would be a practical difficulty and hardship. I have a wall section here showing you the 19 feet of differential between the edge of the eave at the ground level accessory structure and the eave of the proposed addition. And this is a little bigger view of the same thing. So, you know, usually that eave-to-eave separation is designed for transfer of fire or fire retardants and things like that. And you can see in this case, that wouldn't even apply because of the distance between the two eaves. So he plans the addition for the care of an elderly parent, which has to be contiguous to the main structure. It has to fit into the existing floor plan. And, you know, basically, there is no other opportunity to provide for that addition. I mean, the good news about the proposed addition is it does not increase or requirement for a reduction in a side yard setback or a rear yard setback. It's fully interior to the site, and it is completely compatible with the existing floor plan. So just in general, the separation between the eaves is designed for a different purpose. The fact that you have a 19-foot separation between the lower and the upper eave more than meets that criteria. And he really doesn't have any other practical place, as I've shown you on the aerial photograph. It's an ideal location. It's an ideal location for that addition without disrupting the flow of the floor plan or affecting any adjacent property owner. So with respect to the criteria that is involved for reviewing a hardship, these are not self-created hardships except for the fact that he's adding the addition. He more than meets the intent of the code regarding the separation of the eaves because of the height differential. He's not affecting an adjacent property owner and with respect to health, safety, or welfare. The code provides for reasonable alternatives for matters like this, and justice would be done by granting this waiver and variance. So I'm respectfully requesting that you grant the variance, reducing the eave-to-eave separation from 5 feet to 2.9 feet eave-to-eave separation, with the understanding that there's a 19-foot differential from the ground level to the upper level. If you have any questions, I'll be happy to answer.
Okay, does that conclude your presentation?
Yes, it does.
Is there anybody in the audience that would like to speak on this case? Seeing none, we will open it up for board questions. Hearing none, 3 minutes for rebuttal.
No, thank you, sir.
Waived, thank you. Then we will close the public hearing and open it up for a motion, please. Maybe a non-Feldman motion would be nice.
I'll make a motion.
All right, Ms. Walker.
I move that the variance request for case BRB 20-48 for property located at 2808 West Foster Avenue be granted as depicted on the site plan presented at the public hearing for a reduction in the eve-to-eve separation from 5 feet to 2 feet 9 inches based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code. Specifically that the variance will not substantially interfere or injure the health, safety, and welfare of others. The very reason that the eve-to-eve separation requirement is in place is to address fire and safety concerns as evidenced at this hearing. The height differential between the eave of one of the buildings and the eave of the adjacent building are such that these fire concerns are not an issue. and the variance will result in substantial justice being done because it doesn't require any sort of setback or change to the property that would affect the adjacent property owners.
I'll second that.
Seconded by Ms. Long. And a vote, please.
Sam Walker, aye.
Aye. Susan Long.
Dustin Pastor, aye.
Brett Feldman, aye.
Lynn Hurtak, aye.
Motion passes 5-0.
Thank you very much.
Next case is VRB 2057, located at 2913 West San Rafael Street. Is the applicant present? Yes. Sir. All right, Mr. Cotton, please with the staff report.
Eric Cotton, Development Coordination. Up on the agenda next is VRB 20-57, property at 2913 West San Rafael Street. Property zoned RS50, residential single family. The property owners are Ethan and Jennifer Grable, representing himself. The applicant is seeking relief from section 27-156 in order to reduce the side yard from 7 feet down to 2 feet and the west side yard from 7 feet down to 7 feet down to 5 feet 9 inches. Quick location map. It's on the north side of San Rafael to the east of South McDill Avenue. Just a front view of the property itself. And then the site plan, which is, let me see if I can blow this up some. So on the east side, this is the proposed addition. That's actually going to be, this is what's causing the variance from 7 feet down to 2 feet as an existing condition. This is encroaching into the 7 feet, but not as close as that. And on the west side yard, the house itself is sitting at the 5 foot 9 inches. Nothing is being done on this side, but this is an existing condition, and this is the addition they want to add. Board have any questions for me? No? Okay, thank you.
All right. Applicant, please state your name, address, and if you've been sworn.
Ethan Grable, 2913 West San Rafael Street. I have been sworn.
All right, you've got 10 minutes to present your case.
So we bought this house back in 2013, and our family has grown a little bit, and so we want to add a living space in the back, and I don't know that it goes much beyond that. There's a porch that sits there now, and we want to enclose that porch so that we can put a TV on the wall and a couch in the room and condition the space so that we've got a little bit more room to move around. The house was, I don't know what the setback laws were back when it was built. The original structure, I think, was built in 1939. We haven't done anything to encroach or to illegally build on that site. The house is where we found it. We simply want to extend the back room along the way that the house sits now and as it has since it was originally built. We don't want to encroach any further. We just kind of found it. We see it the way we found it, and so we're asking that humbly that you'd grant us the ability to build that room onto the back of the house. It's not going to be an eyesore to anybody from the road, as you can see from the front of the house picture. Where we want to build doesn't encroach on the back. It doesn't even encroach any further on the side. It simply builds along what currently exists and has existed since the house was built, to my understanding, back in the 30s. That's
Okay.
it.
Does that complete your presentation?
It does.
Okay. Is there anybody in the audience that wishes to speak on this case? Seeing none, we will open it for board questions.
I have a question.
Ms. Long?
Your addition is just going to follow the line of the current existing house, right?
Yes, ma'am.
Okay. So you aren't doing anything to add an additional variance,
No, ma'am.
just making sure that the house where it sits now is okay?
Yes, ma'am.
Okay, thank you.
No other questions? You have 3 minutes for rebuttal, if you like.
I think I'm good, thank you.
Okay. Then we will close the public hearing and open it for a motion or board discussion. Anyone?
This is such an easy one. I feel like I shouldn't.
know. I was thinking,
I was letting other people take a shot
like
at
Ms.
it.
Hurtak or Ms. Long might want to
Nobody wants to
take
do
a
it, I'll do
stab.
it.
All right, Mr. Feldman.
I move that the variance request for case VRB 20-57 for property located at 2913 West San Rafael Street be granted as depicted on the site plan at the public hearing for the reduction in the east yard from 7 feet to 2 feet and the west side yard from 7 feet to 5 feet 9 inches with the allowed encroachment of eaves and gutters, based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that the existing home was built in 1939, that it encroaches as currently built into the setback, that the addition, that the owner purchased the home in 2013 and has not made any additional additions or encroachments into the setbacks, and that the addition as proposed and on the site plan does not encroach any further than the current lines of the home, and in fact follows the existing structure along the east side, and no addition is being made to the west side.
I'll second that.
Second, Ms. Long. And a vote, please.
Sam Walker, aye.
Aye. Susan Long, aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Lynn Hurtak, aye.
Okay, motion has been approved, 5-0.
Thank you very much.
Next case is VRB 2058, located at 2316 South Thixton Court. Is the applicant present? Yes. Okay, Mr. Cotton, please.
Thank you. Eric Cotton, Development Coordination. This is for VRB 20-58 for 2316 South Thixton Court. Property is zoned RS 75. The applicant, the property owner is Lois McKean. The agent is Stephen Michelini. This is a proposal for a new single-family home. The required setbacks in the RS 75 district in the front is 25 feet. The applicant is seeking to reduce the setback from 25 down to 10. This does not trigger any natural resources or transportation reviews. This is a view of the existing structure, which will be demolished. This is the aerial photo. Thixton Court ends at this location, then there's a city drainage ditch that runs adjacent to the property. This is the proposed site plan. And you can see the original setback, the original lot went out further. There was a taking by the city for the road itself. The applicant will show you some data. Actually, I guess I can show it to you since it was submitted. This is the property next door. The applicant is trying to line the new structure up with the existing structure to the north. Because of the lot depth being a little bit different in the front, the applicant's seeking the variance request. Board have any questions for me? Thank you.
Okay, name,
Good evening.
address, and whether you've been sworn again.
Steve
please.
Michelini, I have been sworn, and the address is 2407 Sunset Drive. As Eric mentioned, this, the hardship was created when the city took 15 feet of this property and created right-of-way, created a cul-de-sac. And we're trying to align the house with the other houses. We did a front yard setback averaging and drew an arc around the cul-de-sac, and that's how we aligned it with basically, it comes out to the reduction of the 15 feet that was taken. This is a dead end. It has very little traffic on it except for the houses that are located along the cul-de-sac. I think Eric showed you this. And he showed you the, basically the cul-de-sac and how it's developed. There's a drainage ditch that runs along this side of the property, which it constrains us from moving forward, moving to the one of the sides. And we've developed a site plan which we think is sensitive to the conditions that were presented to us. The hardship was not created by the homeowner, but rather by the city taking the 15 feet and then reconfiguring the entire roadway so that 15 feet was missing from the property. We had discussions early on with Natural Resources, and we have a letter from an environmentalist in the package indicating that the ditch is not a jurisdictional wetland, which would have also affected the development area. This doesn't affect any other property owner. It keeps the development pattern consistent with the other homes in the area. It basically was not created by the homeowner. It was created by others. It is consistent with the code with respect to if you were in a different district, what they would call the averaging of the front yard setbacks. And you have that in other districts. But we've done that in this district to sort of comply with the development pattern that's there. The code does provide for this kind of relief. And in some cases, if this were a non-conforming lot under section 27-295, we wouldn't even be here. But because it's a conforming lot, 27-295, if the non-conforming lot is created by a taking, then you have the advantage of the setback being granted basically administratively. But since it's a conforming lot, 27-295 doesn't apply, but we've held to the same criteria that would have been applied if it were a non-conforming lot. The code, as I said, provides for relief in this manner. It's not a self-created hardship, and it doesn't affect any other surrounding property owner, and it does create the same development pattern that exists along the street. So I conclude my presentation and would respectfully request your approval. I'll be happy to answer any questions.
Okay. Is there anybody in the audience that wishes to speak on this case? Seeing none, we will open it for board discussion.
Lynn Hertak, I'm a little confused. You're asking for 15 feet to the front?
Yes.
So what does the ditch have to do with that?
Well, originally the staff thought that it was a jurisdictional wetland, and that would have affected how we asked for our setback either in the front or on the side.
Mm-hmm.
So we had to get an environmentalist involved to certify that that was not a jurisdictional wetland, and that letter is in your file.
Mm-hmm.
So it would have affected what setbacks that we were asking for, and it also would have affected how Natural Resources would have reviewed this proposal, both of which have signed off on it, by the way.
Yes, I saw. So basically, you're just asking for this to balance out with the frontages in the rest of the street.
That's correct.
Okay,
And
thank you.
and to restore the 15 feet that was taken to create the cul-de-sac.
Okay, thank you.
Not restore, you mean compensate?
Right, compensate. We're not going to take the land back, but
Right.
to compensate for the setback that we would have had.
Any other questions? Seeing none? 3 minutes for rebuttal?
No, thank you, sir.
Okay. And we will close the public hearing and open it for a motion or board discussion.
I'll do a motion.
Okay.
Sure I'm doing the right one. I move that the variance request for case VRB 20-58 for property located at 2316 South Dixon Court be granted as depicted on the site plan presented at the public hearing for a reduction in the front yard setback from 25 feet to 10 feet with an encroachment for eaves and gutters based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that they are trying to keep the same distance as other houses and that they are trying to compensate for the 15 feet that the city needed to take for a cul-de-sac for the dead-end street.
Okay,
I'll
is there a
second.
second? Ms.
Yeah.
Muller, second.
Excuse me.
Sam Walker, aye.
Susan Long, aye.
Justin Pastor, aye.
Brett Feldman, aye.
Lynn Hurtak, aye.
Thank you.
Motion has been approved 5-0. Let's please take a 5-minute restroom break. Hard 5 minutes, meaning we will start in 5 minutes.
Buenos Aires, Buenos Aires, Buenos Aires, Buenos Aires, Buenos Aires, Buenos Aires.
Well, we hit 5, but we're going to wait for Ms. Long. Okay, the next case is VRB 2059, located at 2920 West Bay Court Avenue. Mr. Cotton.
Thank you. Eric Cotton, Development Coordination. This is for VRB 20-59 for a property at 2920 West Bay Court Avenue. The property is zoned RS60, residential single family. The property owners are Bhavan Patidar and Murray Patel, represented by Stephen Michelini. The applicant is proposing to, in addition to an existing accessory structure, to increase the size to approximately 1,144 square feet. As a result, the request is to reduce the side yard from 7 feet to 2 feet and the rear yard from 20 feet to 3 feet. The VRB previously approved this request. Let me just show you a photo of the property. This is just a photo of the front of the site. This is a photo of the accessory structure. This was approved under VRB 12-32, and that was to reduce the setback from 7 feet down to 2 feet and the garage entrance from 10 feet down to 2 feet. This is an aerial photo. This is on south side of Bay Court to the east of South McDill Avenue. And just the site plan, as you can see, this is the existing garage that you saw in the photograph. They're adding a second story to this, so the setbacks are measured to the rear property line here and the side yard there. Board have any questions? I'll be more than happy to answer them for you.
So I think the most obvious question, I saw a photograph of a garage and a previously approved
Yes, sir.
variance, so what are we looking at today?
This is a one-story garage.
Okay.
So setbacks run vertical as well as horizontal. So the addition to the second story addition triggers the need for variances for the second story.
Got it, thank you. Okay,
Steve Michelini, I have been sworn. My address is 2407 Sunset Drive. As Eric mentioned, this property previously received a setback for the garage, and it is attached to the main structure, which means that we're asking for main structure setback reductions for a second story. I just want to sort of orient you with some aerial, some photographs. This is the front of the house, and it was designed, this has become the poster child for the Natural Resources Department because of how it's designed and accommodating the oak tree. And that prevents any kind of addition to either the side or the front of the structure. It would also trigger, if you tried to add to the front, it would trigger a front yard setback. This is a view looking along the west side of the property, and that side will be maintained all the way down. This is a picture of the existing garage, and we're proposing a second floor addition onto this garage. And as I said, it's already attached to the main structure, so it's a main structure setback. There's a little closer detail of the garage, and as I said, the request is to add a second floor. And there's the existing connection between the garage and the main structure. Not sure, how do you zoom out on this? There we go. We're constrained on the site by the 40-inch oak that I showed you then in the front, and the off-site oak here, which is showing as 24 inches, but it's much larger than that. So the open space is here where the patio is in the back, and the addition would be here on top of the garage. The petitioner is a doctor, and with the conditions that we're now operating under with COVID virus, the doctors are seeing patients on MyTelemed and other means remotely. And so his proposal would be for using the upper level for his in-home office. The proposal would be to maintain the same plane along the western side and just go vertical. And as Eric mentioned, we have to request a variance for the second level because it wasn't previously granted. Now, personally, the previous setbacks did raise some concerns with me until I realized that there was an existing structure at the side yard 7-2 and 20-3, which are the existing rear and side yard setbacks. But going vertical, we don't increase the nonconformity or the impact to other property owners. It's still interior to the site, and it's far away. Since it's on a corner, we are further away from the next adjacent neighbor to the east. We're not going any closer to them. And providing the covered walkway into the existing structure is a matter of convenience, and it simply adds to the ability for them to access the other side. It's a fairly nominal increase in space, but it is important in terms of operations and allowing them to maintain their home. So with respect to the code, we're not increasing the setbacks. We're maintaining the same setbacks that were previously approved. We're not impacting any other adjacent property owner to any degree that they haven't already been impacted previously. And with respect to the code, we're maintaining the same basic effect that previously would have been met had they asked for this second story previously. It's not a rental unit, which some of the petitions that you get, they come in here and they're asking for rental space. This is for home occupation. And the code does provide for relief for this. We're not impacting adversely any adjacent property owner. And the justice would specifically be done by granting this, and that there is no health, safety, and welfare issue that's triggered by it. We met with Natural Resources extensively on this. Originally, we had planned to do some other additions in a different manner, and this was under when Kathy Beck was still here. They liked this proposal because it had less impact on the existing trees, maintained the same tree canopies, maintained the same coverages and bufferings that already exist. And by going vertical, we don't trigger any of those other issues. We don't impact any trees, and we don't increase the nonconformity of the lot. So I'll be happy to answer any questions you might have regarding this proposal.
Okay. Is there anybody in the audience that wishes to speak on this case?
Mr. Chair, just Eric Cotton, Development Coordination. Just wanted to point out, it is in your packet. We did receive one letter of objection.
Okay.
From Akif Ahmad. I believe he's the property to the rear of this site. You can see he was just objecting to the request. I'm not sure what he means by I do not agree with the footage proposed. I'm not sure he means the setback reduction or the total square footage. I'm not sure if the gentleman is here or not.
I did reach out to the neighbors, and I've had several discussions with them regarding this, and there was some confusion about it because of the setbacks that were being requested. And I think that because it was a second story, there was a lot of confusion about what exactly did this mean. They thought that we were going to tear down the garage and build something closer to the property line. But within those discussions, I clearly outlined to them that this was building on top of an existing garage with the existing setbacks, no closer to the property lines on either side than it previously exists.
Okay. His letter did mention invasion of privacy. Do you want to address that?
There are no windows on either the the east or the south sides. Typically, people talk about looking into their backyards and that kind of thing. And I'm not really sure how to address that because that's a common comment that comes before you. But the windows will only be oriented toward the west side, and the east side, the north side is a connection to the main structure. So I would say that is a invasion of privacy is a minimal impact of any kind.
Would you be willing to accept that as a condition?
Yes, sir.
Okay. Let's open it up for board questions.
Lynn Hertek, where are the stairs?
They'll be internal to the site, from the garage, or they'll be internal on the, it's here where the covered walkway is that already connects the main structure to the outside, but then the connection here to the main house will be a walkway, a covered enclosed walkway.
Okay, so it'll be connected to the house from the main house and not from the outside?
Well, there is one stairwell here that connects to the garage, but that's below this canopy, and you can't really see it here.
Okay.
But it's not on this side, which is where the side yard setback was previously granted, and it's not in the rear, so it's internal to the remaining main function of the property.
So there's no exterior exit stair for the garage or for the second story?
From the second story, no.
Okay.
Mr. Michelini, just to close the loop on the issue with the neighbor's concern, the email that we have in our packet is dated October 20th. Your conversations with the neighbor occurred subsequent to that?
Yes, sir. I've had conversations with neighbors as recently as yesterday.
Okay, but the neighbor...
I haven't seen that email.
Okay. There is an October 20th email. Mr. Cotton?
Yes, sir.
Can he have a copy of that email?
Yes, I'll put it back up on the, hold on.
Oh, there you go. You want to take a moment?
Yes, I see that this is probably I'm just guessing now, this is probably the confusion that related to the side and the rear yard setbacks that were already established. But if we're not putting any windows on the south side or on the east side, that should address that concern.
No, I appreciate that. I just wanted you had represented to us that you'd had conversations.
Yes,
I just
sir.
wanted to understand if it was with this particular neighbor and if it happened subsequent to the...
I've had conversations with several of the neighbors, and it's always been consistently the same thing about the side yard and the rear yard setbacks.
Right.
And there was, because we had to notice it the way we did, it created more confusion than it clarified.
Okay.
But when I explained to them that it was a second-story addition over the existing garage, and nobody was putting windows on the back to, look into their property, they seemed to be satisfied.
Thank you.
Are there any more board questions? Seeing none, You have 3 minutes for rebuttal.
No, sir.
Okay. We will close the public hearing and open it for a motion or board discussion. And please note that we discussed the condition, no windows on the south or east.
I'll go ahead and make a motion.
Okay, Ms. Hurtak?
I move that the variance request for case VRB 20-59 for property located at 2920 West Bay Court Avenue be granted as depicted on the site plan presented at the public hearing for a reduction in the corner yard setbacks from 7 feet to 2 feet, and to reduce the rear yard from 20 feet to 3 feet. With an encroachment for eaves and gutters based upon the applicant presenting.
And I'm sorry, Kamaria Pettis-Knuckle from the city attorney's office. I believe there was a request for a condition to be attached to that.
My apologies.
That's the second one on your list.
With the
Oh, gosh,
condition.
my apologies. Okay, let me start again. Sorry.
Go ahead.
I moved that the variance request for case VRB 20-59 located at 2920 West Bay Court Avenue, as depicted on the site plan presented at the public hearing for a reduction in the corner yard setback from 7 feet to 2 feet, and reduce the rear yard from 20 feet to 3 feet, with the following conditions: that there be no windows on the south or the east side. That said variance as conditioned be granted based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that this is just being added to the already existing garage. The setback lines have already been approved previously, and that this is just going up 1 story and will be internal to the structure.
Second.
Second, Mr. Feldman.
And just for the record, Kamaria Pettis-Knuckle from the city attorney's office. The agent has already accepted the conditions as previously stated.
Would you like me to put that on the record as well?
Yes, please.
Yes, we accept the condition regarding the windows on the east and south portions of the building.
Thank you.
Sam Walker, aye.
Susan Long, aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Lynn Hurtak, aye.
Motion is approved, 5-0.
Thank you.
Next case is VRB 2060, located at 1508 South Arwana Avenue. Appears to be Mr. Michelini again. So, Mr. Cotton.
Somebody new and different.
Eric Cotton, Development Coordination. This is for VRB 20-60 for a property at 1508 South Arawana Avenue. The property is zoned RS50 residential single family. The property owners are Chris and Rebecca Kraft. The agent is Stephen Michelini. The applicant is requesting to reduce the rear yard from 5 feet to 3 feet per section 27-290.3. This is for the construction of an in-ground pool. The DRC had no comments on the request. Just a quick aerial of the property. This is on the east side of Arawana, south of Neptune, north of Mississippi. This is the proposed site plan. You can see the proposed pool in that location. This is the 3 feet along the rear property line. Mr. Michelini did just submit couple of a petition signed by 16 people.
18. 18.
18. Oh, okay, I see it's a different, I see, okay. If you want to, I can read it into the record. It will be part of the record moving forward. This is just basically acknowledging that they're asking for the variance, and if the neighbors have any objection or support, and as you can tell, the neighbors have signed the request. There's 4 on that page. 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 4 on that p this brings it up to, this is the rest of the property owners. There are two separate ones. This is the 17 and 18 that's Mr. Micklin is referring to. These are separate. Let me push this out a little bit, sorry. Separate, not part of the petition, but the same language that was included in the petition. And then there's another letter from a Natalia Silver, which is separate from the petition, say they live at 1510, saying that they support the request also. Board have any questions? I'll be more than happy to try to answer them for you.
Okay. Name, address, and if you've been sworn.
Good evening. Let me just say, first of all, that all of these petitions coming forward on the same evening were not part of the plan, but because of changes in staff and coronavirus, they all ended up at one night. So if you were planning to do this, I would not have planned this, but I certainly appreciate the indulgence of the board. This is a request for...
You still must state your name, address, and if you've been sworn.
Steve Michelini, I have been sworn, 2407 Sunset Drive.
All right.
So anyway, with all due respect, board members, thank you for your time. Let me just show you the site plan first. This is the property, and the request is to reduce the rear yard setback for a pool from 5 feet to 3 feet. And mainly the reason for that is to provide adequate handicap accessibility around the pool. This is a therapy type of pool. We have 7 feet from the house to the edge of the pool, which would provide for stability without affecting the foundation of the existing home, to give you enough room so that you have the ability to maneuver wheelchairs around it, to provide handicap accessibility on the pool side, and to meet the state code regarding the separation on the, that would be the east side of the property. The lot, considering the neighborhood, is relatively small. It's only 50 feet wide, as you can see from the survey, and 101 feet deep. So it's an existing structure, fully developed. This area has redeveloped with new structures throughout the area. And the request is relatively nominal. On the on the east side of the property, it abuts a 2-story garage apartment that's less than a foot off the property line. And depending on which survey you're looking at, some elements of that development may encroach onto this property. So some of the questions that we've had that have come up, that you had 18 signatures from surrounding property owners. The only one, to my knowledge, that didn't sign the petition in favor of this was the immediate adjacent neighbor, Lot 34. Show you some photographs. This is the property line along the east side and the existing structure, so you can see that it's right up on the property line. Typically, if you were building that new, it would be required to be set back at least 3 feet. It wouldn't meet the 900 square feet addition. They would have had to sought a variance for this. This is a close-up of the side, a little bit further down by the corner.
Mr. McLeany, could you slide that down? There you go. Thank you.
A little bit further down, this is the survey showed that the fence encroaches on the petitioner's property, and that the air conditioner from this unit is hanging over the property line. There's a better picture of that. So anyway, in terms of impact to surrounding property owners, you have a massive wall on the east side made up, and there's no windows that I know of on the lower level. The windows are on the upper level. And the impact, any potential impact would be adjacent to a fence and a wall, with the reduction of that setback for the pool from 5 feet to 3 feet. So, and again, this is not for the function of the pool, this is for the deck around the pool to provide for handicap accessibility. This is a survey without the pool on it. So you can see that they're limited in space in the back of the area here. And it's not a huge lap pool. It's a relatively small residential pool, but it does provide an essential service for the petitioners. With respect to adversely affecting surrounding property owners, as I said, the adjacent property owners to the north and to the south of this property, and on either side, except for the one property, have signed letters of indicating of support. Most of those are within the notice area that we provided the notice to as required by code. This is the only space left, and as I said, it's a relatively narrow lot. It does conform with all the other setback requirements for the side and the rear, and with the exception of this pool. And we think that this is a relatively small request to make for the 2 feet without impacting other people. And it does, in fact, there are provisions in the code to allow for this to happen, as well as substantial justice being done. And as far as we know, that doesn't impact the health, safety, and welfare of others. And it is substantial justice would be done with respect to granting the variance. We've tried to discuss this, and I sent out an email that was sent in to the city, and we tried to respond to it asking if anyone had any concerns to please let us know, and that email was not responded to. So anyway, we respectfully request your favorable consideration and approval of this request. As I said, it's a nominal request. It's not for a habitable and structured. It's for a walkway around the surrounding pool to help us meet the city code and the state regulations regarding pools, accessibilities, and handicap accessibility without pushing the pool closer to the house, which could potentially cause foundation and structural issues with the house. So we're respectfully requesting your approval. I'll be happy to answer any questions you might have.
Okay, does that conclude your presentation?
It does.
Is there anybody in the audience that wishes to speak on this case? Take that as a yes? Yes. All right, please state your name, address, and if you've been sworn.
Good evening, Mr. Chairman. My name is John Grandoff. My address is Suite 3700 Bank of America Plaza. I have been sworn and I'm a member of the Florida Bar.
Okay, you've got 3 minutes.
Okay. I'd like to go over a couple things quickly here. Here's the site plan that Mr. Michelini showed you. Regarding the site plan requirements, it's not drawn to scale, and not all the trees are shown within 20 feet of the property, including my client's property, so we feel the site plan is deficient as to the technical requirements. We do not object to a pool. However, a pool is a luxury. It's not a necessity, and they simply need to make the pool narrower, and then they avoid imposing upon my clients who live over here immediately to the east, and we object to the application. Now, what is the problem is that a yard, this is a rear yard is defined as an open space unoccupied and unobstructed by any structure or portion of a structure from 36 inches above the general ground level of the graded upward lot. Open space.
If you want us to see that, you're going to have to pull them down. We can't.
The code?
Yeah.
If you want
sure.
us to see
Oh,
that.
I didn't intend to, but if you want to read it there. you
Oh,
can
no,
read it.
I'm sorry. I just didn't know if you wanted us to be able to see it.
No. If you want to read it verbatim, I'll show it to you.
Thank
But
you.
That's it verbatim. My clients live behind this property, and no, the pool will not be facing simply a wall. This is the non-conforming garage that my clients own. It's a vested, grandfathered, non-conforming structure. You can't bring in my client's structure to get your variance approved. That's basic law. As you can see, the pool's going to be on the other side of my client's wall, so it will be a nuisance to them. But what's the problem? The problem is flooding. And this is a photograph of this gas meter during a significant flood event, which has happened and flooded the garage of my clients and flooded my client's adjacent property. I'll be glad to hand these to you. And in the application, and Mr. McLeany this evening says, quote, "As far as we know, it does not impact the health, safety, and welfare of others." Well, I tend to disagree with that because the elevation of the applicant's property is at 20 feet, and the elevation, pardon me for a moment. If you may hold my time for a second. Okay. The applicant's property is at 20.29. The finished floor of the garage is 19.8. The area about where that gas meter is 19.
About 30 seconds, please.
It's about 19.86. So you have about a foot, a half a foot of change in elevation. There is a significant flooding problem that needs to be addressed. I respectfully request that the petitioners continue the matter to bring an engineer forward to show how they have addressed the flooding issue. My clients have done so with their property. You'll see a drain here. There's more drains here, another drain, another drain. They have to prove that they're not affecting the public health, safety, and welfare of my clients. That has been proven this evening by the photographs, and they admit in their application that the difficulty results from a narrow and fully developed lot. So we have an issue with flooding. We're willing to consider some solution they may put forward. Otherwise, we respectfully request the application be denied.
Thank you. Does anybody else wish to speak on this application? Please come forward. State your name, address, and if you've been sworn.
Francis Devazza. I'm at 1504 South Arawana, and no, I've not been sworn in.
Okay, well, we need to do that then.
Please raise your right hand.
Is there anybody else that wishes to speak this evening on anything at all that has not been sworn in? No.
Do you swear to and affirm that the testimony that you are about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Okay, you got 3 minutes.
So I am the neighbor, what I believe is to the north, directly when you saw the white fencing in some of the areas they were showing of the structure, the gray structure, of the neighbors that live behind them. My wife and I have no opposition to this. We also have a pool in our backyard that was put in 3 years ago, and we have experienced no flooding issues, and actually think that if the pool and the situation of the crafts necessitates the additional space for some of the handicapped members of their family. So I think most importantly, we've experienced none of the flooding issues considering our location to their home and to, I believe, the neighbors behind them.
Okay. Is there anybody else that wishes to speak on this application? No? Then we will open it for board questions.
Mr. Michelini, can you address the flooding issue that's been raised by the neighbor?
Is mic on now? Flooding is a technical issue, and I know that Mr. Grandoff is well aware of the fact you cannot dump stormwater onto any other adjacent property. That's a city code, and city codes regarding stormwater are not waivable. So all of any stormwater runoff that comes from this site has to be contained on this site. And the fact that he's lower than this, I mean, I can't help that, but as I think I showed you the pictures that their gutters on the side of their structure currently dump water onto my client's property, and they weren't coming forward and saying do something about the stormwater. If it's an area-wide problem, then it needs to be addressed by the city in an area-wide manner, not piecemeal. And a pool does not create additional stormwater. Let me just show you this. If you look at this, you'll see that the gutter isn't even attached, and it comes straight down, and it comes right down behind the fence, and is dumped. You see this here? Do I need to move it up? So the gutters that on their side of the property don't control the stormwater on their side. So I don't know how a pool on the other side of the property is going to dump water or adversely affect any adjacent property owner. As I said, the city technical standards tell you specifically you cannot adversely affect any other adjacent property. You must maintain it. And if that means that the crafts have to install their own French drains to convey the water away from that property line, then they'll have to do that. The pool itself acts as a collector. It doesn't, I mean, the rainwater, if there is some, goes into the pool. And then the pool has its own discharge, and not onto somebody else's property. It goes into the stormwater system. So, I mean, I think it's great that they want to talk about stormwater in the area, but they can't point to a pool where you're requesting a 2-foot setback reduction adversely affecting any adjacent property. That amount of square footage, let's assume that it's 2 feet by 100 feet, but it's not, or 2 feet by 50 feet, which is the entire length of the property. That's 100 square feet. And if you add a half an inch to 100 square feet, that is a nominal amount of water. And again, the grading has to convey the water onto their own property, can't go off-site, and so that, you know, essentially they're going to be responsible for maintaining and treating their own water on their own site, just as the crafts are going to be responsible for maintaining and controlling the water on their site. So it's not a matter of narrowing it up. It's a matter of safely placing, as I said, a handicap accessible therapy pool with an adequate separation from the main structure so you don't have structural problems regarding the foundation. And you're also maintaining some distance along the east property line. And there is plenty of area in there for conveyance of stormwater. And certainly if the board wants to make a motion that includes that no stormwater, no off-site stormwater be conveyed onto some other property, that's consistent with City of Tampa code. As I said, that's addressed at permitting. That's not a variance issue. Even if we didn't ask for a setback variance, we would still have to meet that requirement. So, I mean, I'll be happy to answer any questions you have, but it seemed to me that they were resting their argument based upon stormwater and not on technical difficulties regarding the site, which I believe we've demonstrated effectively. I would respectfully request your approval, and I'll be certainly happy to answer any questions you might have.
So I believe that the question of water is because currently the backyard is a depression, as we saw in the pictures. To add a pool, you'd have to build it up to a certain level. that buildup of land creates additional runoff that doesn't exist today because today it's a depression. So your suggestion of a condition that captures and discharges stormwater appropriately might be a solution to that, but I think that the argument was about the buildup of the land less than about the creation of the pool.
You know, we still have to deal with that stormwater on site, even if we have to elevate that. I think there is a differential, as Mr. Grandoff pointed out. There's about a foot, as I recall from his site plan, differential 19 versus 20 feet of existing grade. But when you excavate for the pool, that will be recessed, and then the only thing that should be above that or at the 20 feet would be the decking surrounding the pool. But again, we can put stormwater mitigation measures into place that will address that, including the French drain around the entire east side to convey the water back out to the west side of the property.
What are the dimensions of this lot?
50 by 101.
Okay. So you said that the lot requires these modifications to the pool, but it's a normal sized lot. So my question would still be, why must we encroach on the 5 feet?
As I discussed earlier, it's to provide adequate handicap accessibility around the east side of the pool.
Right, but why not make the pool narrower?
I can't, maybe the owners can answer that. It's relatively, I don't have the dimension here. The pool is only 10 feet wide as it's shown on this plan.
Right. Yeah, but a pool's not a right. You know, a pool is something you can do if you have the ability on your property to do it. So, you know, you can build a small pool or you cannot build a pool. What is the need to go into the rear yard? And the reason I ask is because the most important person affected by a rear yard is the rear neighbor, and the rear neighbor has an issue with this. In the future, there could be a request to do a screen at that point. And, you know, that creates a whole nother level of encroachment that we don't have to talk about today, but it's something that would be, you know, dictated to be closer to that property if this variance is granted. So I'm looking for the hardship that exists on the property that dictates the need for an encroachment in the rear.
Well, let me step back for a second and talk about the enclosure.
And Kamaria Pettis-Mackel from the city attorney's office, that is not a part of the application, and that's not going to, I would respectfully ask that the board not consider any future applications, because that's not before the board. What's only before the board is for the reduction of the setback rear yard from 5 to 3.
Okay. We do often get variances for pool cages that had a previous variance into the rear yard, often. So I just wanted to point it out as a potential outcome, because when those happen, it is very frustrating for us, because now we're in a position where that's already been approved and they want to keep the leaves out of the pool, et cetera, et cetera. So that's my opinion, but
let me just approach that from a different direction.
Not relevant to this case.
From a different direction. That the petitioners would gladly accept a condition of never enclosing that with a pool cage. That's not really the issue before you, but I want to take it off the board. This is not a I got you now and I'm going to get you later on. With respect to the width of the pool, 10 feet is fairly nominal. Moving it further away from the rear yard because of drainage or stormwater or whatever, I don't think is a valid argument, because the City of Tampa Code doesn't allow you to dump water. It maintains it, it requires you to maintain it on your own site, regardless of what the elevation is. And I know you've seen other proposals come before you where we were in the wetland setback area or in a flood zone where the pool had to be elevated to an extraordinary level, and then you ended up with a big berm. And then you had to try to treat the berm and the runoff from the berm with stormwater. And we've done that effectively with those storm drains. Mr. Grandoff showed you storm drains, which essentially are yard drains that go into, they're gravel, and they go into some kind of perforated pipe that's an underground drainage system, which is typical and normal. And, you know, we've committed to doing that certainly along that property line in the event that that is a concern of the board. So the width of the handicap accessible deck around that side is really what's driving the request for the setback. And being able to maintain some reasonable setback off of the main structure of the house without infecting the integrity of the foundation of the existing home. We only have a certain amount of space to deal with. And as I said, it's a handicap therapy pool for their parents that they end up taking care of their children and they're staying there. So it's not just a pleasure, jump in the pool, let's go have a pool party kind of thing. So if there was a way to reduce it some, I mean, we could try to deal with that, but I think that going from 5 feet to 2 feet is a nominal request. And as I said, we cannot, by code, cannot affect any side property line, any rear property with stormwater. It is not possible. They review your plans, they make you install the stormwater mitigation and the stormwater control structures as a requirement. It's not even, you can't even ask for a waiver of that, whether it was a variance or a rezoning.
Did you mean to say 5 feet to 3 feet?
Yes, I'm sorry. 5 feet to 3, the 2 feet is what, the 2 feet reduction is what I was referring to, I'm sorry.
Okay. Are there any other board questions?
Yeah, you've talked a lot about the fact that this is a therapy pool. Is there something special about it that makes it a therapy pool, or it's just a normal pool that would be used for therapy?
Well, it'll have to have handicap accessible lifts on it to allow the wheelchairs access to the pool. And that's why it was being characterized as a therapy pool.
And then I think that this was touched on a little bit, but I just want to be clear. Is there a reason that the pool has to be 10 feet wide and couldn't be 8 feet wide or 9 feet wide and then scoot it back a foot?
I'll have to defer to the owners. They're here. Okay. I can certainly ask them. Chris, come up this way.
State your name.
And you can use that microphone right there. There's a podium.
This one right here. Yeah. Hey.
Before you start, you've been sworn and your address.
My name's Chris Kraft. Address is 1508 South Erewhon Avenue, Tampa, Florida. And I have not been sworn in.
But I just asked if anybody was going to speak to swear in.
I'm very sorry.
All
I
right.
deeply apologize.
Well, let's do it again. Does anybody else in this room think that there's any chance you could speak tonight? Please stand up and swear in.
Stand up.
There we go.
We don't know what they're going to ask.
Do it.
Please raise your right hand. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth?
I do.
Okay. Please
Okay.
continue.
So I think your question's valid, but in our case for the 10-foot, there are other pools on our street. The two houses at the end of our street have had the same request for handicap access in the front and the fact that there hasn't been any issues associated with stormwater whatsoever. So those pools are also 10-foot wide, the two at the end of the street. So we felt that it was a reasonable request being the fact this has been approved in other situations on our street. So that's the reason why we felt like this wasn't an issue, because both of those pools are 10 feet wide.
If I could, Chris, one of the board members asked, could you reduce it to 9 feet or something at less than 10 feet in order to address the issue regarding a setback?
I mean, I assume you could, but I don't see any reason why there's an issue with the setback issue and leaving it 10 feet, being the fact that there's been previous homeowners that have also done the same thing and still have left it at 10 feet. So.
And when you say that other homeowners have done this, they've asked for a variance also?
Yes, ma'am.
Okay.
Did that answer your question?
Yes. Yeah.
Okay. Thank you.
Any other questions from the board? Okay. 3 minutes for rebuttal.
Let me just summarize very quickly that the City of Tampa Code prohibits us from adversely affecting any adjacent property because of stormwater runoff. The stormwater has to be retained and contained on the site. There are no waivers possible. That will be reviewed at the permitting stage if we are granted the variance. And the request was to reduce the rear yard setback for a pool from 5 feet to 3 feet. And that would allow the pathway, the decking around the sides to be handicap accessible, and also provide for the equipment on the west side of the pool for the handicap lifts and accessory equipment that's needed for that. Without moving the pool closer to the house, we run the risk of damaging the integrity of the foundation of the existing structure. I think as the architects on the board know, you can do that, but it would take extraordinary measures to affect that change. So the pool is, according to these dimensions, is 27 by 10, and we're respectfully requesting your approval for the reduction of the rear yard setback from 5 feet to 3 feet, and I'll be happy to answer any questions.
Okay. We will close the public hearing and open it up for motion or board discussion. Anybody? Ms. Long?
I look at this and I say the photographs that Mr. Randolph brought, I'm sure were taken before the pool was put in, because the pool isn't in yet. So the flooding is there whether they have a pool or not. Okay. Will it get worse? I don't think so, but maybe. I'm not an engineer. I have no way of knowing. Okay, so I'm inclined to support this.
Okay.
I agree with Ms. Long's comments. I agree that I don't think that the fact that the neighbor's yard currently floods is convincing to me as to why we should disapprove this application. But at the same time, I'm having a hard time wrapping my head around the reasons that we should approve it. So in other words, like what the hardship is. So I look at the criteria before us, and is this self-created? I mean, on the one hand, they can't, the property owners can't move the location of the house, and the fact that they want to install this handicap equipment does, it sounds like, necessitate the need for a wider kind of deck on the edge of the pool. So I'm on the fence. That's all I have to say about that.
I also am struggling to find a hardship. The hardship is we would like to have a pool, and we would like it to be 10 feet wide.
Yeah.
So I don't see a path for me to support it. If it was solely for therapy, which I doubt it's solely for therapy, but they make therapy pools that you can, twice the size of this table I'm sitting at, that are made specifically for that purpose and are surface mounted. But I'm sure it's for more than just therapy, so that's not necessarily a solution for them. But if we're tying the hardship to the property, I don't see it.
Lynn Hertak, I, just looking at this aerial, see, about a half dozen other pools on the block with similar, that look like they've been wedged into similar small circumstances. So I'm inclined to support this.
Can you tell from that aerial if they are
I
5
can't.
feet or 3 feet?
But I would actually really love for them to be able to come back with some more substantial evidence if others, I would.
Well, I mean, that's certainly an option, but we've got 20 feet from the house to the property line. We've been told it can't be closer than 7 due to structure or extensive cost. They prefer to have 10. I'd rather just move forward unless anybody else feels very strongly that we should delay this further. If, the reality is, if it were to not be approved, they could still build an 8-foot wide pool or a 9-foot wide pool 6 feet from the house. Either way, they can still do that. They don't need us for that. They only need us if they want a 10-foot pool 7 feet from the house. So, you know, it still gives them viable options to build a pool. Would anybody like to make a motion or further discussion? No?
Would someone like to, Kamaria Pettisnapple from the City Attorney's Office, is someone inclined to make a motion? Or further discussions needed?
I can make a motion if I,
Actually, since you're the chair, you can't make a motion.
I mean, I could pass the gavel to Brett, could I not?
If I could, Board,
No,
if,
no.
I was just
No.
going to say a
No,
continuance.
No. It's closed.
I respectfully, Kamaria Pettisnapple from the City Attorney's Office, I respectfully ask that the board consider opening up the hearing, because I believe the applicant, the agent just asked to continue the application. And I respectfully ask that the board consider reopening to entertain his request to continue the application.
Okay, we can discuss that. Is there
I-
any more discussion before we discuss that point? No? Would anybody like to make a motion to reopen the public hearing?
Lynn Hurtak, I will make a motion to reopen the public hearing.
Is there a second?
Sam Walker, second.
Vote.
Sam Walker, aye.
Susan?
Oh, sorry. Susan Long, aye.
Dustin Pastor, nay.
Brett Feldman, aye.
Lynn Hurtak, aye.
All right, let's reopen the public hearing.
All I was going to add was that there seemed to be enough questions where we would respectfully request a continuance, and as I understand it, the next available hearing date would be in February.
If there are still spots in February, Mr. Cotton, do you know?
Eric Cotton, Development Coordination. Offhand, I don't know if there's spots in February. I would imagine you've continued one tonight. There should be an additional spot. The deadline to submit for February won't happen until next month in December. So there should be a spot available.
Okay. Would anybody like to make a motion to close the public hearing?
Regarding this?
I moved to close the public
we
hearing.
just
You would just
Well,
close
he
the
wanted to
public
ask for a
hearing.
continuance.
No, I don't have any.
We can vote without closing
You
it?
just closed the public hearing.
Let's close it. All right, motion?
Lynn Hurtak, I'll make a motion to postpone.
To continue.
I'm sorry, to continue VRB 20-60 to February 9th, 2021.
And can you put the VRB case number that you're,
I did.
okay.
VRB 20-60, correct?
Is there a second?
Brett Feldman, I'll second it.
Okay, vote.
Sam Walker, aye.
Susan Long, aye.
Dustin Pastor, nay.
Brett Feldman, aye.
Lynn Hurtak, aye.
Case has
Thank you,
been
Board.
continued to February 9th, pending space on the agenda.
Thank you.
Okay, final case, VRB 2062, 4502 West Culbreth Avenue. Are you present? Yes. Okay. Mr. Cotton.
Thank you, Mr. Chair. Eric Cotton, Development Coordination, VRB 20-62 for a property at 4502 West Culbreth Avenue. The property is zoned RS 75. The applicants are Brett and Pamela Divers. The agent is John Grandoff. The applicant is seeking to reduce the rear yard from 20 feet down to 5 feet for a residential addition of approximately 132 square feet. The rear yard was previously approved under VRB 14-68 from 20 down to 5 feet 11 inches. there was no issues from natural resources or transportation to not trigger a review for either one of them. This is in Culbreth Isles. Here's the property on the south side of Culbreth Avenue. And this is the proposed site plan. You can see the existing, which was, which was the existing, which was approved, the reduction under the VRB 14-68. In a sense, they're squaring off the lot. They're maintaining the 7-foot side yard, but they are asking to reduce the rear yard from 20 down to 5 feet. The board have any questions? I'll be more than happy to try to answer them for y'all.
Okay. Applicant, please name, address, and if you've been sworn.
Good evening, Mr. Chairman, members of the Variance Review Board. My name is John Grandoff.
Can you turn that on?
I think I
It is
have.
on, you just have to speak louder.
I have to speak louder.
Okay.
John Grandoff, my address is Suite 3700 Bank of America Plaza. And I have been sworn. I have the pleasure of representing Brett and Pam Divers here with me this evening. They'll raise their hand, please. The property is on Culbreth Avenue, not in Culbreth Isles. I just want to clarify that. Some photographs would be helpful. In the previous variance that was granted, in which I handled on behalf of the Divers, the justification was a significant grand tree that was adjacent to their home on the west side. And this gives you some perspective. So we asked for the variance in order to preserve the grand tree because they could not build out to the west. So we built out to the south, and lo and behold, the tree became pretty burdensome to the home, and at the cost of approximately $20,000 was later removed after they completed their construction. The addition is simply illustrated by this, pretty much by this green space. It'll probably be this area. These two windows will be eliminated. A passageway will be here to connect.
Can you please pull that photo down? I can't see the windows.
Sorry. Yes, that's
Thank
better.
you.
So this was the addition that was approved on the previous variance because we couldn't go west. And in this variance, the approximate location of the addition of 132 square feet will be approximately where this green space is. So these two windows will be eliminated. This wall will be taken out. This electrical system will be relocated. And if I may quote from my hardship criteria, the applicants were granted a variance to the rear yard, reducing it from 20 to 5 feet and 11 inches. No neighbors opposed this variance. In fact, they were expressly supportive of it. In order to protect the home, the grand tree had to be removed. Two licensed arborists opined that it would be impossible for both to protect the home and save the tree. Thus, the grand yoke in the west yard was removed on October 28, 2019. Had the applicants known in 2014 that the grand oak would soon have to be removed, they would have opted to forego the variance that we did in 2014 and would have expanded their home to the west side yard. However, they are now constrained with an as-built home whose layout reflects the need to protect a grand tree that is no longer there. The applicants now elect to expand their bedroom to the west. The floor plan would be highly irregular since the bathroom would not connect. It would need no longer be a master suite. Therefore, to preserve the floor plan and theme of the home, the applicants are constrained to extend the master suite into the rear yard, where it's already constructed and situated. To continue the criteria, in line with the code, the applicant expanded the home via the ladder method. Now the home's layout is entirely reflective of the protected tree that no longer exists. I'm going into part two of the second of the hardship criteria. The reason for the 11-inch difference in the rear yard is that the rear line bears slightly northeast since the lot is not a perfect rectangle. Continuing on the criteria, the fourth point, maintaining the stability of a single-family housing area, maintaining a healthy neighborhood, exhibiting quality architectural design, and appropriate form and function in relation to the existing home and surrounding neighborhood. And then I conclude by saying that there's been no neighborhood objection to this. Brett and Pam have specifically contacted their neighbors to the south and to the east, And the Beach Park Homeowners Association has also been contacted, and they have no objection to the application. So we simply come to you now to basically complete the variance and request your approval this evening. And if I may offer any further information to you, I'll be glad to do so.
Okay. Is there anybody in the audience that wishes to speak on this? Please come forward. Use the other podium. Your name, address, and if you've been sworn, please.
My name is Chris Kilborn, and I live directly behind this house at 4501 West Beachway Avenue.
And have you been
And
sworn in?
I have been sworn in.
All right. You've got 3 minutes.
So this is directly behind my pool. The last renovation that they put on the house, I did have an objection to, but my husband did not, so we just let it go. If he were able to be here today, he would say that he has an objection to the one that was recently put on, because it is a huge invasion of privacy. We have a pool that takes up the length of our house, and this renovation is literally looking onto our pool, which is onto our house. Our house has 4 sliding doors on the back of it and 2 bedrooms across the top, and all we see past our pool is the renovation that they previously put on. I can't even imagine another renovation to this. It's so invasive. Everyone who comes to our house just sees this wall with 2 windows and a door. If they were to step out of their door that is elevated from where the renovation is, they're literally 2 to 3 feet from my fence. And I have a picture here. It's not a great picture, but I can show it to you. I just feel that I would hate to think, I've been in my house 11 years. This renovation first happened, I don't know when it happened, maybe within the past 4 years they did this last one, I don't remember. But I would hate to see if we start going up from here too, if after they renovate here, then we go up and ask for renovations on the top, my house will be completely boxed in. I can't, I've tried to decorate the back wall. I've tried to put bushes across it. We still look at the wall to their house with 2 windows and a door. My entire home looks onto this. I feel it's greatly depreciating the property value of my house. It's just not a good look. My family's not able to enjoy the pool as much. Our whole backyard consists of a pool. And it's the length of our house, and all we look at is their renovation. And if my husband were able to be here, he has cancer. He was supposed to pass in March. He's being looked after by MD Anderson in Houston, and as well as the Moffitt Center, because he can't fly to MD Anderson anymore because of the COVID. Because of COVID, my son, who is 14 years old, goes to Beach Park Montessori. He's been there since pre-K, and he cannot go to grade 8 to finish his final year because we can't bring COVID into our house because my husband is susceptible. So I have a home student who is 14 being homeschooled at my house, a cancer patient also, and my husband who's at my house trying not to get COVID. I can't even imagine what this renovation will sound like if they go through with this renovation, putting it onto the back of the house. It's a massive invasion of privacy, and I can't believe that we're requesting another renovation without even the 11 years I've been to this house. Any more renovations on this house, and I really believe that this house is not for these people. And now I can't believe that
It's
possibly
time.
the tree is going to be cut down and they might renovate the other side. I'm extremely upset. I bought my house. I have paid very high property taxes for Beach Park. A lot of people move into Beach Park for big lots, big
time.
trees, and nice neighborhoods. Would you like me to show you the picture?
You can put it on that projector there.
Okay, I've never done this before, but. Okay, this is the fence of my yard. This is their new renovation that they put on with the door.
Got it.
So that's my fence. I'm sure we all know what 3 feet of someone's fence looks like.
All right.
Thank you. And I can answer any questions too.
Okay. Is there anybody else that would like to speak on this? Seeing none, let's open it for board questions.
I have a question
Okay.
for Mr. Randolph. Has the tree already been removed?
Yes, the tree's been removed.
Okay. That's all I had.
Mr. Randolph, I have a question. I'm trying to understand from a site plan standpoint, sort of the history of how this came about. And it would help me if you could pick one of the pictures on the site plan just and depict where the tree was, because certainly the tree underscores some of the position that you've taken in terms of why things were built the way they were for the previous variance and why they're being built as they are now. And I just want to understand where things are situated so that I can understand that position. Would you mind taking a moment to show me?
Be glad to. I'll go right to the site. I've brought the site plan up. Let's see if I can, okay. This is facing north. The tree that was removed was approximately here, spanning this way and then coming in onto the home. That tree's gone. The previous addition was approximately right here. The addition we're speaking of, 130 plus square feet, is right here, simply to complete this master suite, because it messes up the floor plan to go west, and the only reasonable functional addition would be this portion right here. And as I showed you on the photograph, it's
Well,
fair.
okay, so let me just
Yeah.
ask the question while you're raising this point.
Yes.
If the tree, I'm sorry, you said, which way is north on this? On
North's
your-
here. Here's the rear yard,
Okay, all right.
front yard.
So if the tree was.
Not this tree. This tree has nothing to do with it.
Yes, yes, sir, I understand that. So the rear yard, the open space, that's to the west, correct? This side, that's west?
Yes.
Okay, thank you. If the tree was in the west yard, why not just have built the addition at the time? What was restricting the addition at that point?
It was a grant. Can I get the photograph?
Yeah, oh, absolutely.
Yeah, if you have a moment. 'Cause that's the
Go
photograph.
ahead.
The tree, this was the old tree. They couldn't come out west because that would have put this tree at risk of falling on the home.
No, yeah, I get that, I get that. I'm fully situated at this point, I understand. My question is, what prevented the addition, prevented you from just adding that point in the first time you did this variance?
Let me have Brett answer. My client, Brett Divers, would like to answer
Absolutely,
that
go ahead.
question for you. Brett.
Brett Divers, 4502 West Culbreth, and I have been sworn. Thank you. If you can't really see it from that picture very well, but the problem that we had was the canopy of these trees. There were actually two. If you're looking at this photograph here with the one that goes up over the house, there's another one that was connected to it, and there was a combined canopy that was over the entire west side of the house and the back side of the house as well, the back side of the property. So for us to have gone out in that direction would have affected that canopy as well, according to what we were told.
All right, thank you. That's what I was missing.
And one further clarification, if I may, is that there would be no windows on this proposed one-story addition that we're talking about.
Okay.
Thank you.
Are there other board questions? Seeing none? You have 3 minutes for rebuttal.
In summary, as Brett explained, it will be a one-story addition, no windows facing south. This is a de minimis request. We respectfully request your approval this evening, and we had notified neighbors and had not received any objections until this evening, so I want to make a point of that. Thank you for your time.
Thank you. We will close the public hearing and open it up for a motion or board discussion.
All right, so I'll get the discussion started. I certainly understand the neighbor's perspective and concerns about the impact upon the lot. The privacy concerns don't appear to be exacerbated by the addition with no windows in this design that are being added. And it does not increase the depth in which the current encroachment already exists. And I certainly understand why the original tree created an issue and prevented this from happening at the time. So I could be convinced to support this.
Anybody else have any thoughts or motions? You know, I think you made a good point for me, Brett, because I sympathize with the rear neighbor looking at that, which is incredibly close to the property line, and I'm sure it affects the whole feel of the backyard due to the proximity. And when you look at the hardship, it was based on the tree. The tree's gone, but the house is already built, and so the floor plan is set. And so there's only reasonable places you can do additions based on how the existing home was built. So although the tree doesn't exist, the hardship that led to this situation already exists now, and we have to respond to that. So the hardship becomes the existing house, not the tree anymore.
Yeah, and that's, you know, when we look at it from that perspective, it's also a practical difficulty of the existing structures, so.
Yeah, that's a good point.
You know, from the situation of the house, I mean, yeah, like I said, I could support it based upon the fact that there's no windows and it's not going in any closer. It's just sort of filling in that little gap that exists.
I agree with the statements that have been expressed already. One concern I have with approving this application is I'm having a hard time distinguishing between the difference between adding an addition, like I think this is gonna be a bathroom, adding something onto the master suite versus installing a pool. Like neither of them seem to me to be right. But at the same time, perhaps unlike a pool, the City of Tampa comprehensive plan is to encourage development, and the trend is larger houses these days, and so maybe from that perspective it does in fact serve the general intent, and maybe that overcomes the fact that maybe you don't have a right to expand a master suite.
Kamaria Pettis-Nacker from the City Attorney's Office. Just to clarify that, again, this is a variance request, and that you would have to focus on the applicant meeting the hardship criteria. That's the focus of the application, is that meeting the hardship criteria.
Right, so to your point, Sam, whether somebody wants to do an addition or add a pool or whatever is their prerogative if they can do it within the bounds of the code. And if they can't, they have to meet the hardship. In this particular case, the one we're talking about right now, the hardship is that they had to create a house that doesn't conform because of a tree that used to exist. And so now you have a non-conforming house. So, whether or not they need to have the addition, it's not really our purview. It's whether or not we feel like if they want to do it, that they have a hardship that allows that. So, that's for you to decide, but you know, the right to have the addition is granted by right, and then the right to have the variance to do the addition is what we have to discuss based on hardship. But I think in this case, the hardship is the existing house.
Well, and it's interesting that you phrase it that way, because I think it helps me understand a point, which is when you look at those photographs of that tree, I mean, that tree was leaning on the house. They had to cut wedges out of the home to build, I mean, just to allow that tree to stay there. And then the tree didn't stay there because the tree became a bigger problem. You know, and the loss of the tree is a tragedy, but, you know, there are rules, and, you know, if they met those rules, and it sounds like they did, that's not an issue for us. But that tree and those photographs of that tree were the explanation for the hardship, and why they built where they did, how they did. So, you know, once you're in that situation, now you say, okay, well, does that still create the hardship? And it's a practical difficulty based upon the existence of that, or the once existence of that tree.
They're filling in a notch, and that's important to note because they're not projecting any further back than it projects now, or any further to the side than it projects now. The reason they're here for the variance is because the rear property line slants ever so slightly. So even if they match the back of the existing home that was previously approved, they need the variance because it's a little bit closer to the property line because the property line slants. So effectively, they're not getting any closer in either direction because they're just filling in, you know, a corner that wasn't built out originally. That's my perspective, at least.
Did the applicant highlight that?
Yeah.
Okay.
Grandoff mentioned the sloped rear yard line.
Lynn Hertak, I see the sloped rear yard line, but I'm still not sure why they can't go west with it. I didn't see any, I mean, they said that they couldn't, but I don't know what that means. They didn't show me any evidence that says they can't go west. So.
But just for perspective, if that rear line didn't slope 1 foot over the length of the property, they wouldn't be here because they could have just done this by right.
They're asking for from 20 to 5.
Well, because right now it's 20 to 6.
Oh.
You see?
Wait, but if, if they already got a variance.
Yeah, and staff is going to clarify what, okay.
Eric Cotton, Land Development, or excuse me, Development Coordination, they would still need a variance. The original site plan would have been just for the reduction in the setback without the notch. So this would have been, the previous approval would have been for this area. This still requires a variance, whether they were getting closer or not. Even if this was a straight line and they were coming in, they were staying at 5 feet 11 inches, they would still need a variance for this addition.
Why?
Because the previous variances are approved by site plan?
Right, okay.
So.
Yes, I see what you're saying.
All right, okay, thank you.
The tree had fallen on the house and they had to rebuild it. They could have rebuilt it.
Yeah,
without
because it had to match, the notch was drawn into the site plan.
But the point is still understood.
Yeah.
All right.
So would somebody like to make a motion?
Yeah, I'll make a motion.
On our last case of the evening.
I move that a variance request for case VRB 20-64, I'm sorry, 20-62, pardon me, for property located at 4502 West Colbreth Avenue be granted as depicted on the site plan presented at the public hearing, to reduce the rear yard from 20 feet to 5 feet, to build the addition of an existing single-family residence, with the encroachment of eaves and gutters, based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that the property is an unusually shaped lot, that the applicant was forced to build the home and the existing structures of the home to address and preserve a grand tree, that the removal of that grand tree has allowed the expansion of the home, or the previous removal of that grand tree, not connected with this application, has allowed the expansion of the home, and that the home is expanding exclusively along the same lines as the home currently exists, and not increasing into the setback any more than the existing structures. And that because of the practical difficulties of the existing home, this is the most appropriate place to build that addition.
Would you
I'll
accept a
second it.
condition to not have windows on the rear?
Do we feel confident that the applicant has accepted that condition? I mean, it's on the site plan.
Yes, he said that to us.
And he would have to confirm it again on the record if you're going to place that as a condition.
Does he,
No, well, hang on.
does he have to
Can-
accept a condition
Yes.
for us to vote on
I
it?
would ask that.
Can I make a motion first to open the public hearing to
Sure.
allow the applicant to address that?
Sure.
Second.
Second? Anybody?
Second, Sam
All right.
Walker.
Susan Long, aye.
Mr. Crandall, does the applicant accept the condition that there would be no windows on on the side of the addition that's facing the rear yard neighbor?
Yes, I've talked to my clients, Mr. and Mrs. Divers, they accept the condition.
Thank you. Can we close the public hearing?
All right, so I'll amend my motion that there's a condition that the addition include no windows or doors facing the rear yard neighbor.
I'll second that.
Seconded by Ms. Long.
Sam Walker, aye.
Susan Long, aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Lynn Hurtak, nay.
Okay. Motion has been approved with conditions 4-1. Okay. Then, I believe we can adjourn the meeting.
Meus olhos famintos não se cansam de te acariciar. Procuram sempre novo ângulo pra te admirar. E sonham mergulhar na sua boca de